In the Idaho 4 Kohberger case, more court documents are unsealed and made public. Does it shed any new light on the case or just continue the mystery? We're going on 3 years since the Idaho 4 case started, and they promised us that some documents would be made public, and they have, but are we really learning anything new? I'm attorney Andrew Myers. This is the podcast about the law. Joining me is California attorney Yolie Medina. Yolie, how are you?
Hi, I'm fine. How are you?
Not bad, hanging in there. The summer's over now, I guess, or close to being over. We're getting into the fall months. At least here in New England, some of the leaves are actually starting to change, and
Oh,
it's just too
wow.
early for me. What's happening out there in California?
Crazy hot,
Is it
crazy weather. Yeah.
still? So
Yep.
we're two attorneys, one from the East Coast, just outside of Boston, one from Southern California, and we're trying to make sense of some of these documents. And Yolia, you're more on top of these than I am. So where do you want to start today?
Well, let's start with this exhibit. It's an exhibit to a stipulated motion to the admission of additional exhibits as evidence at trial.
Okay. What does all that
And
mean?
well, they stipulated, I guess the parties stipulated that they would allow these FBI reports to come in without having the FBI agents testify. In other words, their experts could rely on the FBI reports, and that's how they would come in. And they stipulated basically to not having to lay the foundation for the documents. And the foundation for the document means that the author or the person who did the forensics, that is the part of the report, comes in and testifies as to what they did, how they did it. This is their report, how they kept the reports, to establish that they did it within their course and duty and scope of employment. And so they stipulated to this. And
The judge said no.
right, go down a little bit.
Okay. I mean, we as
This
attorneys,
is the stipulation, right? This is a
yeah.
stipulation. And then there was an order that was, uh, oh,
Did I go down too far?
oh no, yeah. No, actually, there was an order that came out, but this is just the stipulation, and they unsealed the report that was the reports that were subject to the stipulation.
I think
And
that's in
that's,
a document we're going to look at in a couple
yes,
of minutes, isn't it?
yes,
You and I, as attorneys, both understand foundational requirements. You can't just take documents and introduce them to the jury. You've got to lay a foundation. That's basic in the law of evidence. And so they stipulated, probably because they either didn't want to bring the FBI person all the way from wherever the office is, or maybe they didn't want to open the FBI guy up to additional questioning in an area that was unforeseen. It would seem to me a pretty perfunctory thing to just put the FBI employee on the stand and say, give us your name, how long have you employed, what's your experience with the FBI, were you acting within the scope of the experience when you were, wrote this report? I would think it'd be pretty perfunctory and could be done fairly quickly, wouldn't it?
sure. But the findings of what they found regarding what they did is what I think the court is concerned with. And so there's the report. And if you just go up a little bit, it says it's a laboratory report from the FBI laboratory. So it's to Travis Shirley, relief supervisor of Salt Lake City. But it involves, this was on January 4th, 2023, and it involves the Idaho 4. And the description is trace hairs and fibers. So basically, this was trying to find a link to the victims and the dog, I believe, Murphy, trying to find a link between hairs and fibers to Kohberger at his house or at his in his car.
This was done right away. I mean, look at the date,
Right.
January 27th of 2023. That's only a couple of months after the event, the crime one, November 13th of
Right.
2022. So this was done fairly quickly. This document may contain privileged and or personally identifiable information, including info related to juveniles and other protected information. This document must be afforded the protection required by applicable law, regulation, and policy. If you are not the intended recipient of this document, please destroy it promptly. Well, that's down the tube. So just let me take a look at all the stuff that they're talking about. They obviously did their, you know, investigation at 1122 King Road in Moscow, Idaho, and there's a head hair sample from Ethan Chapin, debris from the right hand of Ethan Chapin, head hair sample from Kaylee Goncalves, head hair sample from Xana Kernodle. What could that be when they say debris from the left hand of Xana Kernodle and debris from the body bag of Xana Kernodle? Head hair sample from Madison Mogen, necklace from Ethan Chapin, bracelet from Ethan Chapin. But what could that be debris from left hand? I have no
I
idea what
don't
that could
know.
be. Oh, good
Maybe they'll
grief.
tell us. Maybe they'll
It go,
tell us in the report.
Earring from Kaylee, fake eyelashes from Madison, ring from Madison, ring from Madison, ring from. So they have 3 rings from Madison Mogen, hair tie from Madison Mogen, a comforter from 1122 King Road, debris from near northwest bedroom on the 2nd floor. That's kind of general. That could be anything.
Well, I guess,
Debris
yeah, debris. Like, what?
Debris from half wall leading to northwest bedroom. Debris from door of northwest bedroom on the 2nd floor. Debris from drying cabinet. Debris from under computer pad on desk in bedroom. Debris from under computer pad on desk in bedroom. Debris from pillow in bedroom. Could that be, hairs? Or no, because they would
It's
specify
debris.
hairs.
Yeah,
Debris. Well, that could be anything. That could be anything. I just threw the wrapper from my lunch in the trash. I mean,
debris.
you know, debris from broomhead.
Definition of debris, please. They
Yeah,
should
it could be
define what
anything.
debris is.
A left sock from Ethan Chapin, right sock from Ethan. Why don't they just say socks? I guess you can't. Left handbag from Ethan Chapin, shirt from Kaylee Goncalves, left sock from Kaylee Goncalves, left handbag from Kaylee Goncalves, underwear from Xana, left handbag from Xana, right handbag from Xana, left foot bag from Xana, shirt from Madison, left handbag from. I think we get the idea. We don't have
Yeah,
to
and
read
there's
them
the
all.
dot. Item 44 is the dog hair sample from Murphy.
Now, Murphy was led away right away. So did they, I mean, in a previous video from the body cam video that we showed a couple of weeks ago, we showed Murphy being led away. So I'm just wondering, did
Yeah,
they,
they
did
got the
they,
hair sample from Murphy later.
oh, okay. Head hair sample from Brian Christopher Kohberger. Arm hair sample from Brian Christopher Kohberger. Blanket from 1122 King Road. Original packaging from item 20 comforter. Filter from dryer. So what would that be? There's a dryer. A lot of student housing doesn't have washers and dryers. You have to go to the laundromat. But so does that mean there was a dryer and a washer in this place?
Yes, there was.
Right hand bag from Ethan Chapin. I hate to sound like an idiot, but these are questions that have to be asked. Pants from Kaylee, right hand bag from Kaylee, sweatshirt from Xana, pants from Madison, filter from dryer 1, catch paper from dryer. There's more than one dryer?
Well, it seems like it. If they're naming it by one, well, there's a lot of people in that house, so
Yeah, yeah. Vacuum container from 1630 Northeast Valley Road, apartment
that
G20201.
that's Kohberger's apartment.
Okay. Oh, okay. Vacuum cleaner from 1630 Northeast Valley Road. So if he had vacuumed his apartment and there had been any hair from the 4, it might be in there. Might be in there. The results of the trace evidence examinations, hair and fiber, are included in this report. Okay, so they talk about the microscopic examination.
Right.
Okay, all right.
And then
We talk about the items that are submitted. Wow. Items submitted from Ethan Chapin, items 3, 12, 13, 31 through 33 and 52. Kaylee, Madison, without reading all the numbers, were examined for hairs microscopically consistent with hairs in the head of hair sample from Brian Christopher Kohberger. However, none were found.
Right.
Wow. Items submitted from 1630 Northeast Valley Road, apartment 3201, items 26 through 30 and 61 were examined for hairs microscopically consistent with hairs in the head hair samples from Ethan Chapin, Kaylee Goncalves, Xana Kernodle, Madison Mogen. None were found. So we're finding that nothing of Kohberger's was found over at 1122 King Road, and nothing of the 4 was found over in his apartment.
Right. And the animal hairs consistent with dog hairs found in item 61, and if I forget what item 61 is, but
Want me to go back?
yeah, let's see what item 61 is. Oh, you want
Vacuum. Oh, the vacuum container. The
Okay.
vacuum container.
So animal hairs consistent with dog hairs found in item 61 are microscopically dissimilar hairs in the dog hair sample from Murphy. Accordingly, Murphy cannot be included as a possible source of these hairs. So Murphy's hairs were not in Kohberger's vacuum container.
And that's really significant because, I have a dog. I have a cat. My cat recently passed away, but I have a dog.
Oh, I'm sorry.
Thank you. The dog hair's everywhere. The dog hair is, I love my dog. I really do. But I mean, she gets hair everywhere. It sticks to your clothing. And the dog is black and white. So no matter what I wear, the black ones stand out on light clothing and the light ones stand out on dark clothing. And, I'm sure that people could find the dog's hair in my car, in my office, and, because it just sticks.
But this dog was a golden doodle, and I don't know that they shed as much as other dogs. They may not.
That's a good point. They're not supposed to. They're not supposed to. But still, on a microscopic level, I mean, I don't know. What's this business about animal hair consistent with cat hair found in items 26 is of limited value for meaningful? I don't remember them collecting any cat hair. Do you?
Well, this is what they found in item 26. So I don't know if you want to. Item 26, they found cat hair. So item 26.
Debris from under computer pad on desk in bedroom at 1630 Northeast.
Oh.
Well, again, my cat was also black and white, and the hair gets all over the place. So, maybe he had a friend or somebody he didn't have that many friends, but he must have, maybe a student had a cat and the cat hair rubbed off on him. I mean, that's really.
Or the prior tenant had a cat.
Yeah, could be, because that stuff sticks like I don't know what, like white on rice. And the debris. Additional debris collected from items 3, 12, 13, and 15 through 20, 30, 48, and 47 has been preserved for possible future comparisons. All right.
So then they talk about how, all of that, how they were examined. The specimens were examined. I don't know that we need to go into all of that.
No, but I mean, I'm sure you have heard the same kind of stuff I have in various trials of other cases where they go deep into the weeds of forensic technology and all the things that they can do now. So, I'm sure that's why, they wanted the report, because they didn't want to go way deep into this. Is this anything significant? You've read it.
Oh, not really. I mean, they're just classifying animal hair and human hair, the characteristics of it. And they can determine the ancestral group of the hair.
Right. Yeah, with DNA they can do a lot. And this is just this is almost like cut and paste out of a textbook.
Right. And then the fibers, they talk about the fibers. The characteristics associated with fibers. That scientific. And how the scientific stuff about it, and then how fibers with similar properties can be excluded as originating from the same source by using identified analytical methods. And so they talk about fibers, and then you go down to the remarks. And it says, for questions about the content of this report, please contact forensic examiner.
I can't believe that they apparently redacted her telephone number, but not her email. So good grief! I can see why the parties, both the state of Idaho and the defense attorneys, wanted a stipulation to not lay the foundation. But I can understand why the judge denied that stipulation because, on behalf of Bill Thompson and Ann Taylor, this is going to take all day. The stuff that we just kind of breezed over and you summarized a little bit. You're going to put an expert on the stand and they're going to talk about the intricacies of the differentiation between different fibers. A person of one ethnic group has certain DNA, a person of another ethnic group has other DNA, and they'll talk about it. And I've actually heard this testimony in other cases, the characteristics of dog hair and cat hair and the adhesion abilities of animal hair or any hair and how different types of hair. So they could go on for days about all this. So I could see why Bill Thompson and Ann Taylor would want to keep this stuff out. But the judge is saying, hey, wait a minute. I'm a judge. This is a legal matter. You got to lay a foundation for the jury.
Because it could be challenged on an appeal. I don't know why it would be challenged on an appeal because it's favorable to the defendant. But nevertheless,
if you're sitting in jail 24/7, if you're sitting in prison 24/7 for the rest of your life, you have time to think of issues for appeal. Trust me. So I don't know. Okay, this is just standard stuff. This is standard. Another report?
Another one, yeah. This is trace hair and fibers.
Okay.
Is this the same? Oh, this is February. Let me see. February 28th.
Yeah, the other one was earlier in January. This one's January 4th and February 8th. Subject is Brian Kohberger. The victims are, Ethan, Madison, Xana, and Kaylee.
This is from the car, yeah.
Oh, okay. Is that what this is?
Yeah.
All right. Okay. So the ones we read before were of the evidence that was collected at 1122 King Road and also his apartment over in Pullman, Washington. So this is the car. Mm-hmm. Oh, good grief. How many things do we have to read here? Oh, boy. Look at all this.
Yeah.
It's head hair from the fore, Murphy's dog hair, headrest from seat in compartment A of the 2015 Hyundai Elantra, debris from behind fall down armrest in compartment C of the 2015 Hyundai, vacuum sweepings from floor in compartment A of 2015. Oh, good grief. Look at all those vacuum sweepings. We're not going to read them all, are we? Vacuum sweepings from various portions.
And then there's pants. 76.
Yeah, I'm looking at that. Jacket.
Now, Lansdowne Drive. Go back.
Yeah.
Could that have been his home in Pennsylvania?
Well, that's what it has to be, I would think.
Yeah.
I would think that's what it has to be.
Yeah, probably, because they're, All right.
Okay, so they're just getting into the stereo microscopy, the microscopy, and all that stuff.
Okay, so here's where the results. So the items submitted from the 2015 Hyundai Elantra and from the 19 Lansdowne Drive were examined for hairs microscopically consistent with hairs in the hair samples from Ethan, Kaylee, Xana, and Maddie, and none were found. So there was no connection.
Nothing in the car.
No. Animal hairs consistent with dog hairs found on items 60, 67, 70, 71, 74, 76 through 80 are microscopically dissimilar to hairs on the dog sample from Murphy. So Murphy can't be included as a possible source of the hairs. They say additional debris from these 65, 67, and 80 have been preserved for future comparisons. And that's basically, they found nothing connecting the car to the victims or the dog.
And this is really important. I know we're going to get comments from people. Well, we knew this already. We already knew this. No, we didn't. It had been said. It had been summarized. It had been, speculated upon. But, commenters have yelled and screamed into their microphones and said, "Yeah, there was no hair from the four in his up." Well, this proves it. This is the source material, and in the law, in trial law. When you go in front of the jury, you have to have your I's dotted and your T's crossed, and you can't just say, well, there was no hair here and there was no animal hair there. You've got to prove it, and this is how you prove it. And so,
even if Van Taylor said there's no connection to his DNA or anything else to the car, to the victims, to the home, to the victims, what she says is not evidence. What an attorney says is not evidence. So here's the actual report of this finding that there was no evidence.
And I know that's a standard jury instruction in the two states, the only two states that I'm a member of the bar in Massachusetts and New Hampshire. I'm sure it's the same thing in California, that what you just said, the jury is told that the statements of counsel are not evidence. The only evidence is in the exhibits that have been presented to you. So this is really
testimony,
important. And I can only imagine, and I would bet the mortgage that although mine's paid off, that's a standard jury instruction in Idaho. This is all stuff that's pretty much the same as in the other report.
And in the remarks,
and we're not going to dox the forensics examiner, Karen somebody or other. So that's those two reports. Karen Lowe. Okay, so that's that one. That's that new report. So let's go to the next one. What is this crazy order? We both read this before we went on and tried to figure out what this is, and that's as big as I can make it. But what is this all about?
I don't know, but it looks like Brian Kohberger wrote in there.
looks like a doctor wrote it.
Yeah.
Order. No,
okay.
We read this before. Now I can't make it out again.
Order conditionally denying admission of additional exhibits as evidence at trial.
What does that mean?
Okay, so this is the FBI reports that we were talking about. Yeah,
the one we just read.
Right.
The two we just read.
So they wanted an order to be allowed to stipulate as to the admission of these exhibits without having to lay the foundation with the FBI agent who did the testing or whatever.
Okay.
And the court denied it, and it said evidence will not be admitted unless offered with the appropriate witness
at trial,
as was explained at the conference, at the pretrial conference.
Okay, so now I have actually gotten what they call marginal orders, where the judge will write stuff in the margin of the document. But I think we discussed earlier that the better practices in the federal court practices that the judges themselves may not write the orders. They have us write the orders, but at least they're printed out. They ask you, Attorney Medina, I want you to go back to your office and type up an order and send it to me, and it darn well, better, reflect. But if it's a simple matter like this, I mean, look at that. That's like not even two sentences. That, one of us could have typed that up on our word processor and sent it into the court. So, I don't know. It's an order. It's a court order.
It is.
So then the next document, order maintaining sealed status. So what's this? Just the court is saying that certain records that have been sealed in the past will continue to be sealed. Item 9, I'm not going to read them all, but item 9 must remain sealed as it is replete with identifying information of the proffered alternate perpetrators, the unsealing of which could contravene the privacy concerns in these individuals and likely subject them to unwarranted harassment and reputational. I think we kind of have a good idea who they were, don't we?
I think so. However, now I'm kind of questioning that, but I have an idea.
Yeah, we all have idea. We don't have to go into who they were, but because I think, tons of podcasters have speculated, and we've talked about it before. But the judge is saying, although a court is immune to libel and slander, as long as the statements that they're making in their orders are, as are attorneys, prosecutors and defense attorneys, as long as what they say is in good faith and in the conduct of their prosecuting and defending. So I don't know why this couldn't have been made public. I mean, the court's concern is harassment and reputational harm. Well, their names have been out there. Their names have been out there. The two Jacks, or two of them.
The two Davids.
The two Davids. Yes, the two Davids.
Yeah. So it's very unfortunate that there's been harassment in this case and threats. And, I was just thinking about the threat that was made to the Goncalves family when they were giving their victim impact statements. Ms. Goncalves received a text. I don't know if you've heard about that, right?
Yeah, that's horrible. It's not right. It's just,
It's
no
not
matter how
right.
you feel about this case, we can all have different opinions, but to, actually take the step of, harass, it's none of your business. It's not your business to go harass people. It's really not. So that's it.
And then it says the remaining, the last one says the remaining identified records all relate to an ongoing and statutorily confidential investigation into potential leaks in this case and are exempt from disclosure. So there's two reasons. One, the alternate suspects motion, the information regarding the identifying information of the alternate suspects is sealed. And then the other documents that he's talking about in the order is because of this confidential investigation regarding the leak.
Yeah, remember that was that late spring or early summer when the documentary, which documentary was that?
Dateline.
Dateline, yes, Dateline. When Dateline came out, it was obvious that people had leaked information to the network, and it seemed that it was much more likely than not that it came from the prosecution side. And the judge became, I have to categorize the documents as indicating that the judge was angry. Is that fair?
Yeah, no, he was upset, yeah.
And he ordered them all to come up with information. Was it 7 days? And then he scratched it out and said 5 days, something like that.
Something like that.
And,
But yeah,
he wanted information with regard to everyone who had access to that information. I'm thinking to myself, that could be anyone. That could be, an office assistant, an intern, an attorney. I doubt if it would be one of the attorneys, but you never know. It could be anyone,
FBI
really.
agents, FBI agents, Idaho State Police, Moscow Police. I mean, the number of people, my goodness.
These agencies are replete with, hacks. So anyhow, that was way back in the late spring, early summer, and so they still haven't figured out who leaked the information. Interesting.
And tonight there is a 2020 episode on the Idaho 4.
Again? Another one? Really?
Yes, 2020 on ABC.
Okay, so we have to tell people that we record these things on a Friday afternoon. The Friday that we recorded this was September 5, and then we drop the episodes over the weekend. So by the time we do this, it will have been, which network did you say?
ABC.
I'm not going to give my acronym for what ABC stands for, but I've done it before. So I'm sure it'll be available to people. Okay, so enough about that. That's interesting that you knew that.
Yeah.
I said in an episode that I don't think you were here for because you took last week off. And I had said that ever since, I don't watch TV anymore. Ever since The Big Bang Theory went off, there's nothing on TV that I really watch.
Yeah.
But anyway, I digress.
Yeah.
What's this?
It's on YouTube too. I saw it on YouTube actually. There's
Yeah.
a trailer. There's a trailer for it.
Okay. Now
Oh, boy.
this is, you wanted to point out a couple of things in this document. This is, for our viewers, this is the Statement of Constitutional Rights. Anytime a defendant pleads out, they are required to give an affirmation that they understand all of their rights that they're giving up, and that's what this is. And he himself filled it out. And you're going to give more substantive analysis of this document, but my first thing was, look how scribbly his writing is, because he actually was required to fill in the blanks, and his writing is terrible.
Yeah. I mean, I'm sort of used to terrible writing. Well, not anymore, but before medical records became electronic, I used to read a lot of doctors' notes. I
Yeah.
couldn't, you'd have to take their deposition and actually have them read their note into the record because it was undecipherable. I was like, what is this? Just
Well, that's why they made the records all electronic now,
Yeah.
and I could shorten a war story. I tried a dental malpractice case one time, and I put the dentist on the stand long before he was expected to go on the stand, so it took him by surprise, and I made him read his notes because you're required to bring your original notes, the copies that go through whatever. I asked him to read his notes, and he himself had a hard time reading his own notes, and the jury just sat there going, "Yeah, right." Okay, I digress. So
actually, we're going to the questions regarding his ability to enter into the plea. Let's see what's that. Yeah, questions reability, and we're going to number 5. Let's start with 5.
okay, go ahead.
So they ask, are you currently under the care of a mental health professional? And he says no. Have you ever been diagnosed with a mental health disorder? Yes. If so, what was the diagnosis and when was it made? So he talks about the diagnosis of autism level 1, obsessive compulsive disorder, that is different from obsessive compulsive personality disorder, not to be
Okay.
confused with that.
Okay.
ADHD, attention deficit hyperactivity disorder, and ARFID, which is avoidant restrictive food intake disorder. And that is eating or picky eating due to sensory issues related to fears of choking or just bad reaction to food. I don't know. Hopefully I summarized that okay.
No, I think you did a good job.
Yeah.
It's a fear of eating
Yeah.
more than what the limited things that you want to eat. Are you? So that was interesting. That 5 is, are you currently under the care of a mental health professional? No, but then 6, 1, 2, 3, 4 different things. So,
Right. The other thing I wanted to make note of is he puts February 2025, that's when he was diagnosed. So according to Brian Kohberger, his understanding is that he was diagnosed in February of 2025. That's his understanding, and that's based on the experts that evaluated him on behalf of the defense. Now,
right.
if so, these experts were sort of doing a dual duty. They were going to provide reports for the guilty phase, but also for the mitigation phase.
Right.
So for the mitigation phase, they would have had to have gathered materials from his youth. And in the declaration or affidavit of the expert, I think it was Dr. Orr, they would have to talk about what they relied upon, any records that they relied upon in coming to their conclusions, any past school records, any past medical records. So without looking at the declaration of the expert, Dr. Orr, and seeing the affidavit, which I believe is under seal, then you'd want to look at what she reviewed, because it may be that he was diagnosed long before, but didn't understand it, and now he's just putting February 2025 because this is a part of a legal proceeding, and he has a report that says it that's right in front of him.
Plus, it's also everything you said, I'm sure, is correct, but absolutely. But you only have one little line there. And so, how can he put down his entire history on one little line there? I often think that when I'm given like one form to fill out, I had an audit I had to complete the other day, and they're asking me questions, and they have little teeny tiny little spaces. Well, how much is that all you want? You're auditing, and that's all you want is one little line? So, I mean,
you can put see attachment A and then put the attachment. Like,
yeah, I mean, does he have a word processor at his disposal that he, I mean, and the other thing that I question, I hear a lot of people saying, talking about autism and talking about OCD and talking about ADHD. But if you look at the statistic diagnostic manual, to actually be diagnosed with these things, it takes time. It takes the background material that you're talking about, but it also takes, evaluation in a clinical setting where, it's one-on-one. It's the patient and the doctor. And so I always question that when I hear people say, well, so-and-so is diagnosed as having A, B, or C. I always question that. I don't know.
Right. And so then he's on levothyroxine, which is a thyroid medication for hypothyroidism.
That's nothing. I mean, if you don't take it, anecdotally, my dog takes it. I've known human beings that take it. If you have a thyroid condition and you don't take it, you become very lethargic and your energy level decreases. So, but that's not levothyroxine. If you don't take it, it's an issue. But if you're taking it, it's not going to affect your ability to understand and speak and communicate. Right. So that's why we get to that. I thought this was interesting. I don't know if you did. I thought this was interesting. Number 8, in the last 48 hours, have you taken, and anytime you do a colloquy, if someone has pled guilty, anytime there's a colloquy, the judge always asks this question. In the last 48 hours, have you taken any medication or drugs, including over-the-counter, or have you consumed any alcoholic beverages which you believe affect your ability to understand these questions or to make a reasoned and informed decision in this case? Looks like he said yes.
Well, I think what he did was he read the first part of the question, and assuming that the second part wouldn't change his answer, so he wrote in the last 48, and he wrote yes because he read, in the last 48 hours, have you taken any medication or drugs, including over-the-counter, or have you, and when he read that, he said yes. He checked yes, and then he continued reading and said, oh, no, that's not right. And then checked no. But of course, that's just my speculation. I don't know.
That's what I thought too. So yeah. Great minds think alike. But then when he X'd out no, he initialed it. So
one last thing on this is that because he's not being treated by a mental health professional, and because he says he has these disorders, these, I guess, mental health disorders, according to him, because autism isn't necessarily a mental disorder, but according to Brian Kohberger, he believes it is. And because he's not getting treatment for that, I would think in my mind, I'm not a criminal, as a judge, I would think that the judge probably should have asked, you have these mental disorders. Are you aware of that? Are your mental disorders in any way affecting your plea agreement here today? Is that affecting you in any way to plead guilty? Just to sort of make it airtight. And most likely he probably would have said no, and it would have been fine. But it just kind of leaves something open there.
Because that's not objective. That's him saying it. Of course, he's his own best advocate, so he's going to say no. But I don't know. I'm not saying that that's true in this case. But if you want the plea to go through, you're going to say, oh no, I'm not under mental or substance influence that would diminish my capacity to understand the proceeding. Of course, you're going to say no. But it's an open question.
And then we're going to 21 and 22.
21. Has anyone told you what your sentence will be? Yes. 4 fixed life sentences, consecutive and without the potential for parole, as well as 10 years. All right. 22. This is a big one. Appellate writes, is this a conditional guilty plea in which you are reserving your right to appeal any specified adverse ruling? No. What rulings have you reserved the right to appeal? None. So, it is said that he understood fully that he was waiving all of his rights to appeal, even though the United States Supreme Court, in a case that I briefed in a previous episode, has said waiving your rights to appeal doesn't waive your rights to appeal. And those were the words of the good Judge Hippler himself. So
right. But he did waive when you think about what he's waived, and he waived the right to appeal the Franks motion, the alternate suspect motion, the motions in limine. And I think it would be very hard for him to appeal those orders. And I think that he can appeal. I would assume if there's evidence that contradicts that he did it, because they didn't ask for allocution at the sentencing hearing. They didn't ask him to tell them where the knife was or explain the crimes or anything like that. If new evidence comes out that he could not have done the crime, then I don't know what that does to him, to his post-conviction relief, if he has grounds, or so.
Well, yeah, it was said that he had 42 days under the Idaho rules, and as we record this episode, those 42 days have passed. However, if you go deeper into the Idaho rules of criminal procedure, one rule says that you have up to 2 years to move for a new trial if new evidence that couldn't have been found under due diligence previously indicates either that you did not commit the crime or that somebody else did. So that's an open question. I'm only a member of the bar in Massachusetts and New Hampshire, but that is actually a rule that's on the books in Idaho. So
Yeah,
I don't know.
interesting.
Yeah, so I don't know.
Anyway, those were the only
Yeah. This is, other than that, this is fairly standard stuff when you plea out, or I should say when a person pleads out. These are the questions that are asked. Have you had sufficient time to discuss your case with an attorney? Yes. Et cetera, et cetera, et cetera. So we have all three of his attorneys signing off. Ann Taylor is the scribbly one. Then we have Eliza Massoth and Bicca Barlow all signing off on this form. So that's it. Okay, so that's it for the documents. It's interesting. A lot of it is legal intricacies, but they're really important in a case like this, where so many people have questions, including us, and it has been such a big case. So let's go to our viewer comments. Do you want the odds or the evens this week?
I'll take the evens.
Okay, so the first comment that we have this week is from Susan Blackstone, and she says, in my opinion, they let him off. So, and we have to, these are the comments that people make. So this is representative of the comments that we get. People are on both sides of this issue, but Susan, in her opinion, they let him off so easy. He supposedly killed 4 people. If anyone deserves the DP, he should have had to give details as part of the plea deal. Why not? Well, you just mentioned allocution, and for whatever reason, Bill Thompson claimed at the time that, we wouldn't believe anything he said anyhow, but then, in an interview with Nate Eaton of East Idaho News, Bill Thompson actually said something very interesting, and he said, well, we believe everything that we did was correct, but, yes, we don't feel necessarily that we would be able to prove everything he said, which I thought was an interesting comment.
Well, Brian Kohberger hasn't said much.
No.
Throughout this trial. So I don't know where they base the fact that he would have lied anyway, because he hasn't said anything.
Well, no, this was a hypothetical. Why didn't you?
Yeah.
Why didn't you ask him, for allocution? Why didn't you at least ask him where the knife is? Why didn't you at least ask him, because then they could go out and corroborate it. But that's what Thompson's response was to Nate Eaton's request. And if I've mischaracterized, my apologies to Mr. Eaton, but that's the way that I recall it.
Yeah. Let me see. Okay. This is from Herman Hale. I thought our TVs, computers, routers, and other things are spying on us all the time. You'd think the TV in the main room should have had a record of some sort if that was true. And that TV disappeared between shots in the crime photos. It did. I noticed that. This is the TV that is in the second floor living room at 1122 King Road.
Yeah.
I don't know if our TVs are spying on us, but I just assume that I'm being watched, so I don't do anything bad.
I always had this question, with Alexa. There have been stories of people sitting around talking to themselves in their living room privately. Geez, do you think we should get a new car? I don't know. They're so expensive. Well, what will we get? If we got a sedan, it might be less expensive, but no, I like an SUV. Alexa picks it up, or the TV picks it up, or some listening device picks it up, then the next time you go on Facebook, all you see is ads for cars, geo-tracking. So
Yes, that's happened to me. Uh-huh.
it's happened to a lot of people that I know. It's happened to a lot of people. And that shocked me with 6 young people living in that home. They would have more electronic stuff than you and me. I don't have an Alexa. My
I don't.
refrigerator doesn't talk.
Neither does mine. And I don't want it to.
No, I don't either. I see these appliances and I don't want it to do that stuff. I just want it to. I want the refrigerator to keep the food cold. I want my washer to wash my clothes. I want the dryer to dry them. And I'm at the risk of being called old. You're old, but I'm still here. So I always wondered why we don't have something. Why, we don't have video that they took. It's just, I don't know. It's a quandary, and I think Herman Hale makes a good point.
Yeah.
Dorothy Middock, I hope I said that right, says, thank you for bringing up the 8 hours that they didn't contact the police. No one has ever explained those 8 hours, and that raises a ton of questions. I hate to beat this question with a dead horse, but it's an important one.
Yeah, it is. And especially after watching the body cam, it just raises more questions that if it was so frightening. Digital Vood says, I just figured out one of the reasons why they tore the house down. I know they did a 3D scan and all that, but when they tried to claim that Kohberger could have committed all the M's in under 3 or 4 minutes, or the little time they claimed, and actually took a jury into the actual home and tried to reenact that, it would be impossible in that time frame. Now that the home is gone, that would not be as effective as a 3D simulation.
Yep, that's true. That is very true. That goes to those reports that they said that they went in and they timed
They
themselves.
recreated everything. Yeah.
Yeah, and as you correctly pointed out, no, there are crime scene experts who can actually go in and recreate the scene. And they ran up and down the stairs and said they could have done the crime in a minute and a half. And then they said, well, we'll do it more deliberate. And they went back and they figured it could have been, 2.5 minutes, 2 minutes and 45 seconds. No way. If there's anybody that believes that, come to my office Monday morning and I will sell you a deed to the Verrazano Narrows Bridge for $10. Okay. I think it's Tina B. She's a regular. Thank you, Tina. I think it's because everyone was drunk and the 2 surviving roommates were afraid to call the cops, getting in trouble because they were underage drinking. Just doesn't make sense that they didn't call anybody sooner. They said they heard cries and screams. What makes you think there's nothing going on? Do you have any comment on that one? I really don't. I mean, again, we're beating this 8-hour delay with a dead horse, but it's a good question and it's been not answered. The frozen shock phase is out the window because they were talking back and forth and texting back and forth and running up and down the stairs. Sure, frozen shock phase of about 15 seconds. Sure. And the toothache, no. No. I've had a toothache and it's not pleasant. It's not fun. It's not a good thing, but no. That is not an excuse for an 8-hour delay, so I don't know. Do you have any closing thoughts for us, Yolie?
No, other than the appeal date is closed, so now it's just the unsealing of all of the information and what surprises we might find.
Yeah, I think you're right. And I guess the other thing is there is that rule in Idaho that you dig down into the rules, and if new evidence is surfaced that could not in good faith have been discovered earlier, that shows that someone else did the crime, there's that little bit of wiggle room. But, Mr. Kohberger did knowingly, willingly, freely not only fill out that waiver of rights form that we just went over, but he went in front of the judge and said yes all 4 times. The judge said, are you pleading guilty because you did do the crime? And he went through all 4 of the victims. So I don't know. We've been accused of being pro-burgers. I'm not a pro-burger. If the guy did it, what?
There is one last thing I wanted to say, but finish your sentence. You were saying
if the guy did it, I agree with the first comment that we just read. I mean, he's not in the Ritz. You can't expect them to be catering to every need. There's no room service or pool or, gift shop. No. I mean, if the guy did it, that's the way it goes. But, people have jumped all over me. I'll personalize it to me. People have jumped all over. Oh, you're a pro-burger. How could you possibly? I'll tell you how I could possibly, because there's so many holes in the case, and people like myself are justified in asking questions. We're allowed to ask questions, and until the questions are all answered in this case, I'm not the only person that's going to be asking questions. And I have a suspicion that asking questions period is going to last a long time. In this case. Rant over. Your turn.
One last thing that I did want to say is, if Brian Kohberger really was the person who hated women, who wanted to degrade women, as a lot of people in the media are talking about him in that fashion, then I would have expected him to file an appeal based on ineffective assistance of counsel, because that would be the ultimate slap in the face to his female attorneys. And he didn't do that.
Yeah. A lot of people have pointed out the irony between, as you point out, it was said that he was pretty abusive to some of the women over at Washington State University when he was a teacher's assistant, and he was very unpleasant and overbearing to the female students. And so, it's a good point. It's a really good point. But then not only did he have all of that, let me complete the thought, but then he had, female attorneys, Ann Taylor, Eliza Massoth, Becca Barlow. Now there's Jay Logston, but, so people thought that was quite ironic, but, you're right. He didn't bring an appeal based on that. So the last question I always have, I have an idea, but do you have an idea for what emoji we should ask people to leave if they've been with us through the whole episode?
Something about a lab report.
A lab
report.
A black lab or a yellow lab or a profit lab?
Beakers.
Beakers. All right.
Beakers, microscopes. I don't know.
Anything having to do with a lab, a beaker or a microscope or any test equipment,
DNA.
Anything like that. A what?
DNA.
Is there there's no emoji for DNA? Is there?
There's an emoji for a virus, maybe. Yeah,
there's emojis. I'm surprised there's emojis for everything. So, all right. Thank you very much, Yolie. Appreciate it. And please remember to like, subscribe. I forgot to ask people to subscribe while we were doing this episode. That's on me. But, leave comments. Be nice. I really don't like it when you call people names. If you think that, you're a moron. No, I stop reading them. Or if you start calling people names, you're a whatever. No. Please be nice, be kind. You don't know what the person on the other side is going through. You don't know their life. You don't know, what they might be going through at this time. So instead of calling people names or, saying, if you don't believe this, then you're an idiot. No. Start a new string. Don't deride one of my nice commenters, no matter what they say, even if they don't agree with me. They're a nice commenter and hopefully a subscriber. Start your own stream and tell us what you believe. It's okay. 1 million people have disagreed with me. It's all right. So be nice, be kind. Thank you very much, and have a good one. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.